how we operate as businesses that were associated with the COVID lockdown measures are lifting, but it's still quite confusing for many of you. There are lots of rules that are applying out there. Still, there are still many restrictions on how business operations are occurring. Some of those restrictions have been lifted. Some will be lifted in future. Other restrictions will stay in place. There are new constraints and directions also that will be introduced in relation to dealing with unvaccinated staff, unvaccinated clients, in relation to ongoing efforts to maintain the operation of the Victorian economy and assist business with the recovery. So today we're going to hear from some experts from Hunt & Hunt Victoria who are going to present to you today. And so we have three very experienced principals who are in turn experts in their fields. Firstly, going to hear from David Thompson, who runs Hunt & Hunt's Workplace Relations, Employment and Safety team. Then from Graham Scott from our Litigation, Insolvency and Dispute Resolution team. And finally from Steve Aitchison running our Property and Construction team. Ladies and gentlemen, the plan today is that we will firstly run through the roadmap rundown to help you plan ahead for your, to help your business and your entity plan ahead. We'll go through some of the key dates and milestones. We will also deal with returning to the workplace. What are the key directions and regulations? What are the provisions around the mandatory vaccinations and current public health orders? We'll deal with employers' duty of care, occupational health and safety issues, and some of the concerns about exemptions and vax refusals. We'll also hear about the debt recovery and insolvency regime. What are the status of the current measures put in place by government to constrain actions against businesses that are struggling financially during these challenging times? And we'll also look at some of the provisions about electronic execution of documents. Are we, like Marty McFly, going back to the future here? What will the position be regarding execution of documents going forwards? Are we back to the wedding signatures, the hard copy documents that need to be exchanged for legal effect? What is the position going forward? Finally, Steve Aitchison will help us out with the position around commercial tenancies and the relief scheme, what remains in place and what are tenants and landlords' rights. We will also address some of the key dates and milestones, and just a reminder that as of 6 p.m. tomorrow, the rule will be that you must work from home if you can, but you may go to work if you're fully vaccinated. So work from home if you can, but if you're fully vaccinated, you can go to work. Now, if that sounds confusing, or hopefully we can explain a little more about that today. Of course, excitingly, retail, hospitality, entertainment, personal care is reopened for the fully vaccinated as of tomorrow. Looking ahead, we estimate the 24th of November, when we will have, we hope, 90% of Victorians over the age of 12 fully vaccinated. Some further constraints will be lifted and we can return to on-site working. Ladies and gentlemen, today's webinar will be recorded, and we'll send a copy of the webinar out to all of you who have participated. In the meantime, we will leave a provision for answering questions at the end of the webinar. So please put your questions in the chat function, put them forward. We're really happy to answer any questions that you have. Our experts will be reviewing those, and we'll leave time at the end of the session for that. But over to David Thompson now to present on workplace relations issues.
Thanks for that, Tony. Just getting the IT setup done. So welcome everyone to today's session. I'm going to give you an update on the situation in relation to COVID vaccinations with four potential or four primary topics. Issues relating to whether there are relevant public health orders mandating vaccinations in your workplace. Secondly, your statutory duties of care under workplace health and safety legislation and whether they allow you to independently mandate vaccinations. Thirdly, dealing with employees who do not have valid exemptions or continue vaccine refusal conduct. And finally, just briefly, dealing with privacy issues concerning the collection of records relating to vaccination status. A lot of these slides I'll be skipping over fairly briefly, and I'm leaving for you to look at your leisure as I'm covering a bit of content, but there are also issues that I can cover independently with you at a later date if necessary, if you need advice. So the situation around the country, not only in Victoria, is changing on a weekly basis. Vaccination levels around the country are rapidly increasing. In New South Wales, we had a recent Supreme Court decision rejecting a challenge to that government's vaccination directions. And there's a similar case on foot currently in Victoria. Unfortunately, the guidance we've had from the federal government and from the Fair Work Ombudsman, its regulator, for employers has, in my view, been poor. The government has lacked leadership. And then we've also had problems with the public health orders issued in different jurisdictions and various mistakes and corrections. And so it hasn't all been plain sailing. So mandating vaccinations for employees, what can you do? Employers can legally mandate employees to have COVID vaccinations. Firstly, in three situations. Firstly, where there's an applicable federal, state or territory public health order, and we've had some new ones recently, and I'll discuss them shortly. Secondly, you can mandate vaccinations if you have an enterprise agreement that allows that. Now, that's currently highly unusual unless you've recently renewed your agreement and included a vaccination clause in it. And thirdly and finally, you can issue a vaccination mandate to your employees if it constitutes a lawful and reasonable direction. And that's the critical one for most of you if you're not currently covered by a public health order for all of your employees. The justification would be based on your policy, and in turn, that's based on satisfying your workplace health and safety duties of care. There is a caution there, however. It's important that you consider every individual circumstances and objections before you make a final decision requiring them to have the vaccination. It's blanket policies that get employers into trouble in relation to falling foul of anti-discrimination legislation. So let's look at the current public health orders. They cover workers in a variety of areas, residential aged care in all states and territories, healthcare in all states and territories, quarantine in 6 jurisdictions, transportation and airport workers in New South Wales. And so those first four categories there are have been the critical areas for transmission over the last 18 months or so. And then more recently, we've had public health orders introduced in the area of education in New South Wales, Victoria and the ACT, and that's been due to recent outbreaks and of course our lengthy lockdowns. Then in construction in Victoria, where it wasn't necessarily considered a dangerous COVID industry, but because there was a lot of non-compliance by employees in the industry, the Victorian government introduced those. And more recently, we've had public health orders introduced in 3 jurisdictions, Victoria, Tasmania and the Northern Territory, in relation to workers as defined in the particular health orders. And I'll talk about them in Victoria in a minute. There are some subtle differences in relation to these public health orders. For example, in Victoria, the obligations under the orders are on employers or the operators of work sites, and that's due to the flavour of the Victorian government being a Labor government. And by contrast, in New South Wales, the primary obligation is on workers, not on employers. and that's due to the flavour of the New South Wales government being a Liberal government, of course. So although there are secondary obligations on employers in New South Wales, the primary ones are on workers. So I'll have a look at the Victorian directions, as everyone attending here today operates in Victoria, and a number of you operate elsewhere around the country as well. But the current public health orders in Victoria are twofold. There are the mandatory vaccination specified facilities directions, and believe it or not, we're up to the 10th iteration of those directions, and they cover residential aged care, they cover construction sites, and for example, the dates for construction sites, the relevant dates are that from a month ago, the 30th of September, no one could enter a construction site unless they had one vaccination by that time and showed evidence of that. And then from 2 weeks into the future, from the 15th of November, no one can enter a construction site in Victoria unless they have been fully vaccinated and provide the relevant evidence for that. Now, in relation to healthcare facilities, there's a really wide definition that's outlined there. It covers hospitals, ambulances, community health, general practices, dental, pharmacies, etc., etc. So it is very, very broad in its coverage. And in relation to education facilities, that covers both public schooling and private schools, as well as early learning centres. So that has a very broad ambit as well. Now, the second lot of directions, which was more recently introduced, are the workers' directions. We're up to iteration number 5 of those already. The first set of those directions came into operation with no fanfare at 11:59 p.m. on the Thursday, the 7th of October. Indeed, there was no pre-warning about when these would be published. And I know I had many clients who'd been waiting for a week since the Premier's first announcement, waiting on tenterhooks as to when the details would be provided. Well, eventually they came through overnight. And in relation to those directions, firstly, the first 4 of those directions, versions of them, included really a comedy of errors in some areas. For example, in our area in legal offices, the number 1 set of directions applied to lawyers only and not support staff. The number 2 set applied to lawyers and support staff. Then they were revoked, and the number 3 set applied to lawyers, support staff, but excluded lawyers and support staff who worked in litigation in the courts. And it appears that was a mistake and totally unintentional. What they intended to exclude was people who worked actually in the courts, not in law firms working in litigation. So those directions lasted 24 hours and were revoked for iteration number 4, which sent us back largely to the number 2 version of the directions. And they expired a week ago, last Thursday night, and the number 5 version, the current version, is in place. And that is largely similar to the number 4 version and just changes the dates of operation. So it applied from last Friday and proceeds until the 18th of November. Now, these workers' directions in Victoria apply to 33 categories of workers, so a very large section of the Victorian economy. And I've listed the 33 categories in that slide. And the definitions are either confined to specific workers in those areas, but in fact, most of them usually also cover workers who work in connection with that work. So it covers a wide variety of people who work in that area as well, including office staff. In relation to the public sector, and I know we've got a lot of people from local government here today, versions 1 and 2 of these directions seem to forget local government employees, but lo and behold, version 3 didn't. They suddenly included local government workers. There's still, however, not a lot of logic behind some of these directions. For example, in the professional services category, they do not include accountants, nor do they include architects or engineers, although they may be construction sites. a little bit bizarre because it's not inherently more dangerous to work in a legal office or a local government office than it is to work in an accountant's office. So they are very arbitrary, but that's the nature of health orders. Okay, so moving on, what are the grounds for vaccine refusal? Essentially, they are threefold. They are medical, political, and religious. And the medical ones, the relevant exemptions in the directions are extremely limited, and I'll discuss them a little bit later. But in relation to the political ones, the most common objections tend to be along the lines, you can't tell me what to do, my freedom's in jeopardy, it's my human right to determine what's put in my arm, or anti-vaccination sentiments generally. So ignorance and fear. Objections, and I've seen it many, many times in the objections provided by the employees of clients over the last few weeks or so. Significantly, however, the laws do not allow people to be forcibly restrained whilst the jab is put in their arm, as some of the anti-vaxxers would have you believe. There is still some element of choice, but there are also potential consequences arising from that choice for people's employment and general freedoms to move about outside and go to restaurants and bars, etc., etc. In relation to religious objections, most religious objections lack clarity, and in fact there's no major religious group that has officially discouraged the vaccine, and even conservative Baptist pastors in the US are saying there is no credible religious argument against receiving the COVID vaccination. And in my experience, it's only been the Russian Orthodox Church as one of the mainstream religious organisations that's actually opposed the vaccination. The significant issue is, however, that in relation to political and religious objections, they are unlikely to be sufficient to prevail because workplace health and safety prevails over them. We are in a pandemic. We're dealing with a highly dangerous and highly infectious Delta strain. And so health and safety trumps everything. That's my view. Okay, now let's consider the legislation just briefly. Mandating vaccinations is a lawful and reasonable direction if it's justified by your statutory workplace health and safety obligations or the inherent requirements of the role. And we have workplace health and safety legislation around the country, and fortunately there was a model workplace health and safety act that was introduced, and it's been adopted everywhere except Victoria. So there's one version of the act that's identical everywhere else. And in Victoria, we're still the outliers, and we have our Occupational Health and Safety Act 2004. However, the most important parts of the legislation in our act are close to identical to the Model Act anyway, as the Model Act was actually largely modelled on the Victorian Act in the first place. So in relation to these issues, there was also a recent judgment of the New South Wales Supreme Court on the 15th of October, and the court there dismissed proceedings brought by a total of 10 workers in health, aged care, construction and education against Brad Hazzard, the New South Wales Health Minister, and the Chief Medical Officer. And there, the court stated that although it was contended that the objected to orders of other freedoms, in fact, on a proper analysis, this is not the case. The orders do not authorise involuntary vaccination of anyone. Instead, what they do is curtail freedom of movement, which in turn affects a person's ability to work and socialise. And curtailing freedom of movement, including movement to and at work, the court said are the very type of restrictions that the New South Wales Public Health Act clearly authorises. There's currently a similar case before the Victorian Supreme Court alleged. And my view is that will the Victorian Court will come to a similar result. There were also decisions, instructive decisions at the in April this year relating to two employers, one in the early learning industry that introduced a policy that people have flu vaccinations in June of last year, and they dismissed an employee for failing to have the jab, the flu jab. And secondly, another one in New South Wales involving a community aged care facility, Sapphire Aged Care, where they dismissed a receptionist for being in breach of a New South Wales public health order that no one must enter a high care nursing home without an up-to-date flu jab. And both of those decisions upheld the right of the employer to dismiss. And in the case of Sapphire Coast, that decision was appealed. And a month ago, on the 27th of September, a majority of the full bench of the Fair Work Commission upheld the employer's right to dismiss in that situation. So, getting back to the legislation, what is an employer's primary duty of care? In Victoria, it's on employers, and elsewhere it's on a PCBU, a person conducting a business or undertaking. And the primary duty is twofold. Firstly, to employees to provide and maintain a working environment that is safe and without risks to health, so far as is reasonably practicable, and they're the magic words. And then the obligation is to persons other than employees, such as contractors, clients or customers, again to ensure they're not exposed to health risks, and so far as is reasonably practicable. And what do those words reasonably practicable mean? Well, the legislation outlines 5 factors that employers must take into account in discharging their duty of care as to whether they've looked after health and safety so far as is reasonably practicable. The first factor is knowledge about the hazard or risk and ways of eliminating or minimising it. Now, in relation to COVID, it's not an obscure risk. There's plenty of knowledge about it. Secondly, the costs of eliminating or minimising it, and COVID can't be eliminated, it can be minimised. Certainly, it costs nothing to mandate the vaccination. Thirdly, the availability and suitability of ways to minimise the risk. Is COVID an easy risk to minimise? No, it's not, but vaccinations are the best way to do it. Fourthly and fifthly, and these last 2 points are the most important ones of all, you need to look at the degree of harm that might result or the consequences from the risk arising. In other words, for unvaccinated people to contract COVID, what are the consequences? Well, they're clearly potentially catastrophic, involving death, serious lasting health issues, or long COVID symptoms which might last for weeks, months, or even longer. And the fifth factor is the likelihood of the risk occurring. And in relation to COVID, the Delta variant, it's so infectious that for unvaccinated individuals, the likelihood of them contracting it has got to be between likely and extremely likely. In fact, our Chief Health Officer has said fairly recently that over the next couple of years, all Victorians are likely to get COVID. So what you need to do as an employer is do a risk analysis. That involves putting a risk matrix in place where you have down one side the likelihood of the hazard or risk occurring, and down the bottom, across the bottom, the consequences that might result. And if, as is likely, you'll be up on the right-hand side where it's extremely likely people will get COVID and the consequences are really severe, then that means to satisfy your health and safety obligations, you need to act. And that's a highly relevant issue. Okay, now aside from mandatory vaccinations, in order to satisfy your statutory duties of care, you need to focus on all relevant risk control measures as well, not just mandating the vaccination. And this slide is just for you to look at your leisure, but certainly having things like a cleaning regime in your workplace, having reception do daily temperature checks on everyone who arrives, potentially introducing rapid antigen tests, particularly where you have employees who might have medical exemptions. If you're happy for them to still attend work and they're not prohibited from public health orders, then the rapid antigen testing is one thing you could consider introducing. Right, now mandatory vaccination policies. What format should they be in and what content should they contain? You can have a formal policy that's 8 or 10 pages long, but you don't need to do that. That's the important thing. All you need to do is make a decision and communicate it clearly. That's the critical issue. So the format doesn't matter. And in terms of content, if they're based on a public health order, you need to reinforce the wording of the public health order. If it's not based on a public health order and it's just your own policy mandating the jab, then you need to outline what the requirements are, when people need to make a booking and when they need to have jab 1 and jab 2, and why you're doing it, and your justification is your own risk assessment in order to discharge your own health and safety obligations. And indeed, for you potentially to avoid WorkSafe coming in and potentially looking at charging you for breaching those obligations if you fail to meet them. What are the medical grounds for refusing vaccinations? Now, the options there are, firstly, you can request a letter from the treating doctor of the employee, or suggest that the treating doctor notify the Australian Immunisation Register that they have a vaccine exemption, and that will in turn display on an IHS, an immunisation history statement that is supplied to the employee on their mobile. And so that will take into account the medical exemptions that are in line with the ATAGI clinical guidance on COVID vaccinations, and that's what the public health orders have been adopting as well. Okay, so medical exemptions. Can you request a medical exemption? Can you request or go behind a medical exemption that has been granted? Absolutely you can, even if it's in a medical certificate or an immunisation history statement. And I've got a couple of examples of this just to walk you through. This is a medical certificate that came from an employee of a client, and it states that this is to certify that this particular named person is undergoing specialist assessment for serious medical concerns and is exempt from the COVID jab for a period of 3 months from today. So it says there's an assessment for serious medical concerns. It doesn't say they have serious medical concerns or what they are. They might be ingrown toenails. It doesn't say, importantly, that the person has an acute medical condition, which is one of the grounds under the Victorian health orders under which it can be an exemption can be granted. So in that situation, I drafted a letter to the client indicating that the employee to provide to their employee, and that indicated that the employee was not compliant and in breach of the directions, and requested them to obtain a more detailed letter from their doctor. And lo and behold, the employee, after a bit further obfuscation, ended up booking a vaccination. Secondly, I had another employee of a different client provide an IHS, an immunisation history statement, which is a formal Australian government document, a digital certificate that certified that this individual has a medical contraindication to COVID-19 vaccines, but there was no more detail. So the employer was aware that their employee was not keen on having the jab and was a bit suspicious about this. So I prepared a letter for the client to send to its employee, asking the employee to obtain a letter from their GP outlining the actual reasons for the exemption, just to ensure that they were compliant. And lo and behold, what was the response? Well, a letter came back from the GP indicating that this person presented to me requesting an explanation for the basis of her vaccine exemption. It was requested by another doctor who left the clinic, and unfortunately, I am unable to provide any explanation for the exemption. In other words, there was none. So I followed up by preparing a script for the client to have a conversation with the employee that she wasn't breached, and she's now had her first jab as a result. But just back in relation to the medical grounds for refusing a vaccination, in the public health orders in Victoria, they are extremely limited. They apply if you are an accepted person. An accepted person means, firstly, if you have a medical contraindication, and there's a specific definition of that, and that means if you have anaphylaxis after a previous dose or to any component of the vaccine. In relation to AZ, if you've got a history of 2 medical conditions, either capillary leak syndrome or thrombosis. In relation to Pfizer and Moderna, if you've previously experienced myocarditis or pericarditis attributed to a previous dose of the vaccine. So they're extremely limited. And the only other ground is if you have an acute medical illness. So it's got to be something pretty damn serious. All right, now what if employees refuse to have a vaccination? What can you do? Firstly, my advice is you provide them with a written direction that they have the jab, indicating it's lawful and reasonable. And if they don't have or comply with your direction, then the consequences will involve the termination of their employment. That then allows you to dismiss the employee based on two factors: the inherent requirements of their role and refusal to abide by lawful and reasonable directions. You can also potentially transfer them to other duties involving working from home, if that is feasible and it's not in breach of a public health order. Or again, if it's not in breach of a public health order, you might be prepared to have them attend work, subject to them having daily rapid antigen tests before they attend. And finally, another option, but not required for employers, you can reach agreement on them taking extended leave, be it paid annual or long service or unpaid leave, until the COVID situation might calm down in a number of months. Now, to finish up on in relation to vaccine requirements and records, privacy issues, if a public health order applies, you can certainly request details of the employee's vaccination status. That's possible in all jurisdictions around the country. Can you collect records of the employee's vaccination status? Yes, you can. That collection is mandated by the orders in Victoria, the ACT, NT, Queensland and WA. It's also mandated by implication in New South Wales because you must take all reasonable steps to ensure compliance. And whilst it's not mandated in South Australia and Tasmania, my view is you can require it in order to reasonably comply with the public health order requirements that are imposed on you there. And where there's no public health order, my advice is still that you can require people to provide their vaccination status and collect records where that's justified by your statutory health and safety obligations. And yes, it is personal information and health information, and that raises privacy issues. However, there is an employee records exemption in the Privacy Act, and these are employee records, so they are exempt. But for example, the records of a job applicant are not exempt until and unless that applicant actually becomes an employee. Finally, in relation to mandating vaccinations for contractors, customers or others, if they enter your worksite, can you do this? Firstly, you should check whether there's a relevant public health order that applies. And if there is no relevant order, you can still mandate it if the health and safety drivers are strong enough in your business. And 98% of the time, my view is that is the case, but we can assist you with legal advice on those issues. All right, that's it for me now. I will hand over to Scott, who will be talking about some of the financial issues arising out of bouncing back from the lockdown.
Okay, thanks, David. I think I now have the con. So hi everyone, and thanks for joining us. Today I'll be looking at some things for business owners and managers to keep in mind when we navigate out of the lockdowns, including some basic principles and some new laws. Now, as we know, the impact of the lockdowns has seen many businesses suffer hardship. A tsunami of insolvencies was anticipated, yet counterintuitively, there have been far fewer insolvencies in the same period than in comparative periods in prior years. It was, however, unsurprising that external administration slowed in 2020 due in large part to the federal government's relief and stimulus measures. Now, as we're starting to emerge from the lockdowns, statistically, the number of external administrations still remains low, and the usual pressure points which drive appointments are absent. With tax debt owing to the Australian Taxation Office reaching record levels, in October it hit $53 billion. the ATO has recently indicated that it's moving into a phase of enhanced engagement with taxpayers and anticipates that this will bring about an increase in insolvencies in the second half of the financial year. That said, the imminent federal election in early 2022 may slow the progress of the ATO's recovery efforts. So unless pressure to bear is brought from other quarters, such as trade creditors, banks, landowners, this insolvency malaise, I think, looks set to continue into the middle of next year. With the stimulus measures and grants coming to an end, liquidity will now be tested. It's quite likely that businesses will eventually be confronted with insolvent or distressed trading partners. So in 2020, the federal government introduced a number of relief measures. The relief package included a temporary increase in the threshold for statutory demands from $2,000 to $20,000 and bankruptcy notices from $5,000 to $20,000 and a corresponding increase in the time for compliance from 21 days to 6 months. Now, those relief measures have now ended. Where debts are not paid within ordinary trading terms, a statutory demand is a useful and cost-effective tool for creditors to recover trading debts. Effective from 1 July this year, the minimum threshold for a statutory demand increased from $2,000 to $4,000, and the time frame for compliance remains at 21 days. A failure to comply with a demand paves the way for a creditor to apply to have a company wound up. It's not a precondition to serve a demand that a creditor first obtain a court judgment, so a creditor can avoid the cost and delays associated with a court claim. Where a debt is disputed, however, a claim should be made in the courts in the usual way. These claims can be quite costly and may take many months to reach trial. Accordingly, a negotiated commercial settlement may provide a more expedient outcome. Bankruptcy notices function in a similar way to statutory demands. However, they're directed to individuals, not companies. Unlike a statutory demand, a bankruptcy notice can only be served where there is a final judgment. Also effective from 1 July this year, the minimum threshold for a bankruptcy notice increased to $10,000, time for compliance 21 days. Failure to respond to a bankruptcy notice is a precursor to a creditor then applying to court for a sequestration order, which effectively makes a person bankrupt. Of course, an individual who's labouring under a mountain of debt may choose to enter bankruptcy voluntarily and lodge a debtor's petition. To make sure that directors had confidence to trade through the COVID crisis with the aim of returning to viability when the crisis passed, directors were temporarily relieved of their duty to prevent insolvent trading. The temporary relief ended on 31 December last year, so directors once again must ensure that when a company incurs a debt, there are reasonable grounds to believe that the company will be able to pay its debts as and when they fall due. Now, insolvent trading claims, of course, can only be made by companies when they are in liquidation. Also on 1 January this year, the federal government's post-COVID small business restructuring reform package came into effect. This package introduced 2 new insolvency regimes for small companies, including a debtor in possession restructuring and a simplified liquidation process. Now, to be eligible for the debt restructuring process, a company must have all tax lodgements up to date, not necessarily the tax paid, and have all employee entitlements paid, and importantly, the threshold there being creditors of less than $1 million. Under the new regime, directors will work with a restructuring practitioner to prepare a plan which is put to creditors for a vote. And throughout the process, the director remains in control of the business, unlike voluntary administrations, and can continue trading while implementing the plan. Despite very strong anticipated demand for this restructuring, there have been only 22 thus far nationally. A simplified liquidation was introduced with the idea of allowing small businesses with limited resources to access a more streamlined winding up at a lower cost. Again, to be eligible, a company must have all taxation lodgement obligations up to date and have creditors of less than $1 million. One of the major differences in a simplified liquidation is that a liquidator may only pursue unfair preference claims of amounts greater than $30,000, and the payments must have occurred within 3 months of the winding up. There's no threshold, however, for related parties. Now, this is a nice segue into unfair preference claims generally. They are the most common claim by liquidators, ostensibly to generate a pool of funds for distribution to creditors. Where a creditor has received a payment in respect of an unsecured debt within 6 months in a normal liquidation of the winding up, they can expect a letter from the liquidator demanding that the payment be disgorged. Now, as mentioned, there have been few liquidations during the lockdowns and, as a consequence, few unfair preference claims. So I think it's likely this will change in the ensuing months. Creditors can resist preference claims if they can prove that at the time of receiving payment, they did not know or suspect that the company was insolvent. Now, evidently, with many companies adversely affected by the lockdown, they're very likely to be insolvent or on the cusp. Some laden with tax debt, surviving only because of the relief measures, including JobKeeper. So it seems that creditors may find it a little bit more difficult to argue the defence that they did not know or suspect that a company was insolvent at the time of receiving payment. In the financial year, 30 June 2021, the ATO reported only having instituted 6 bankruptcies and 3 court-ordered liquidations. Now, these figures are remarkable and pale by comparison to historical data. The ATO has indicated that there will likely be increased recovery action excuse me, in the second half of this financial year in a measured and appropriate way, it said. As a result of its re-engagement, the ATO said it expects winding ups to recommence. However, a federal election must be held no later than May next year, and typically the ATO are not active immediately prior to an election. So it seems that an escalation of recovery activity may not start in earnest until after then. The ATO can also report businesses to a credit reporting agency when tax debts exceed $100,000 and which have remained outstanding for 10 weeks, and where the taxpayer is not considered to be effectively engaging with the ATO to manage its tax debt. Early engagement is the key in dealings with the ATO, who in lockdown have been generous in granting payment plans and extensions of time for lodgement. Directors have a legal responsibility to ensure that their company reports and pays its tax and meets its superannuation obligations. If it fails to do so, the ATO can issue director penalty notices to directors who may become personally liable, and in some instances, the personal liability is automatic. There are 2 types of DPNs in the ATO's armoury, which can be used or issued to directors to recover unpaid PAYG withholding, GST and superannuation guarantee charge. They are known as non-lockdown DPNs or lockdown DPNs. If a company lodges its BAS and SGC statements by their due dates but doesn't pay the corresponding debts, the ATO can issue a non-lockdown DPN. Now, a director can avoid personal liability if they pay the debts or place the company into liquidation or voluntary administration within 21 days of the notice. A failure to take these steps will result in the director being personally liable for the penalty. Where a company does not pay its PAYG, GST and super guarantee charge and also fails to make its lodgements by the due dates, the ATO can issue a lockdown DPN. In this case, the director's personal liability is automatic and can only be prevented if the penalty is paid within 21 days of the notice. A lockdown DPN can also be issued after the company goes into liquidation or voluntary administration. The ATO can also estimate the company's debts for PAYG, GST and super and issue a DPN based on those. So the key takeaway is to lodge all BAS and SGC statements by their due dates, even if payment cannot be made. A new director has 30 days from the date of their appointment to pay or appoint before any pre-existing liability can attach to them. The ATO can also issue a DPN to former directors that were appointed at the time the outstanding debt was incurred. So it's prudent for outgoing directors to ensure that all obligations to the ATO are met at the time of their resignation. There are limited defences to DPNs, but which, due to limited time, I don't propose to canvass in this presentation. From November, directors will need to apply for and verify their identity as part of a new statutory requirement for them to have a director identification number, a DIN. So a DIN is a 15-digit number used by each eligible director of an Australian company, as proof of their identity. Now, this new regime was created with the purpose to promote good corporate conduct and to deter and penalise directors' involvement in the illegal phoenixing of companies. The deadlines for submitting a DIN application differs according to the date on which the director was or will be appointed, which you can see on the table in this slide. It's critical for suppliers of goods on credit with retention of title clauses or goods under hire arrangements to register the security interests arising under these transactions on the Personal Property Securities Register. There are strict timeframes for registering a security interest, generally within 20 days of execution of a trading or hire agreement. A failure to register or to register outside the statutory timeframe may result in a loss of rights in the goods or conceding priority to another party. Applications can be made to court for relief in case of delays. However, these applications can be unpredictable and very costly. Businesses will need to be vigilant to ensure that a valid registration or a new registration is made against existing and new customers. So check your PPSA registrations to ensure they are valid and effective. And having a valid security interest may also provide the basis for a defence to an unfair preference claim. From 14th of August this year, companies can once again electronically execute documents. Now, these recent changes largely mirror those that were implemented during last year's lockdowns and will once again ease pressure on companies having trouble facilitating wet ink executions. For now, the changes are temporary and lapse automatically on the 31st of March next year. However, the government does intend to implement permanent reforms before the measures reach their sunset date. The changes to the Corporations Act allow a copy or a counterpart of a document to be signed by a company electronically, provided three things. Firstly, a method is used to identify the person signing, and that method indicates the person's intention to sign a copy or counterpart. Method is not defined by the Act, although having regard to the explanatory memorandum, this requirement can be established, for example, by using a digital signing platform such as DocuSign, which automatically inserts the signatory's name and digital signature when signed, or by signing the electronic document with a stylus tool, a finger perhaps, or a mouse, and the signatory returns the document with a covering email acknowledging electronic execution and an intention to be bound. The second requirement is that the signed copy or counterpart must include the entire contents of the document. So where the execution page is commonly extracted from the larger document and signed in isolation, the requirements of section 127 will not be satisfied. Thirdly, the method of execution used must be reliable. The Act does not mandate the use of any particular means of execution, so any method of electronic execution would be considered reliable, including, once again, using a stylus tool on those electronic pens, your finger, or a mouse, by copying and pasting a signature, or by signing in wet ink and scanning in, or using a digital signing platform. The new laws also expressly permit execution by companies, or split execution by companies, rather than the traditional requirement of both signatories executing a single static physical document. Finally, where a company executes a document with a common seal, which is unusual these days, but remote witnessing of that is also permitted, and the slide explains the occasions on when that is allowed. So what comes next? I touched briefly on this before. There are temporary changes which are likely to be made permanent. There are new laws which also make temporary amendments to the Act to permit the use of virtual meeting technology for directors and members' meetings. That includes meetings to be held in a fully virtual format, provided that members have a reasonable opportunity to participate, documents relating to meetings to be provided and signed electronically, and electronic minute keeping. And as I mentioned, the government, it's undertaken a consultation process to make some of the temporary provisions permanent. We're waiting on the release of the bill for confirmation of these changes, which will take effect from the 1st of April 2022. Well, that's all from me for the moment. For now, it's over to Steve.
Thank you, Graham. Just Belinda, I seem to have lost the presentation. Sorry, just bear with me for a sec. Okay, let me just.
Okay,
Thank you. Just try and go to, here we are. So as I think everyone would be aware, as part of the sort of government response to the COVID pandemic, commencing early last year, various iterations of a tenancy rent relief scheme have been implemented across all states. They're all slightly different, but basically pretty much the same. And I just wanted to talk about, I guess, some looming problems in terms of the accumulation of rent liability that's going to sort of hit the market early next year. So I'll be really quick with this, but I just wanted to sort of begin by giving a bit of context. So everyone will know that the basic structure of the rent relief scheme that has been enacted is that commercial and retail tenants are entitled to a rent reduction in proportion to their decline in turnover during the COVID period. Now that rent reduction is, according to the concept, is to be shared between the landowner and the tenant, generally by 50% being waived by the landlord, and the other 50% of that reduction being treated as deferred rent, meaning that it's effectively postponed and payable at a later time. Now, I'm just going to really quickly demonstrate how that is going to impact the world early next year with this little chart here. So if you look at this chart, each of the bars represents periods during the COVID pandemic. So the first period was effectively April to September last year, so that was 6 months. And that bar represents a proportion of rent paid and a proportion of rent deferred. And then immediately after that term, the rent relief scheme was extended for another 3 months. And as a result of that extension, the deferred rents were effectively kicked down the road a bit further and postponed until the end of the COVID period. But as the COVID impacts kept rolling late last year, we had another extension, which took us from January through to March. And then at the end of March, the rates were the COVID rates were down, and effectively everything went back to normal. But it didn't last that long. So we had a period, obviously earlier this year, of no COVID restrictions, but then it all started again late July. So we then had another period of COVID rent relief, which is still currently in place. So the current period of rent relief runs from effectively the beginning of August through to the 15th of January. So what that means is retail and commercial tenants have continued rent relief through to mid-January. So that takes them through the Christmas period, even though restrictions are beginning to relax now and hopefully will be pretty well removed through the Christmas period. But the impact of that, if you look at the last column in this chart, is that all the deferred rents from the previous 4 periods of rent relief have now accumulated, and they're all going to start to be repayable on the 16th of January. So in theory, all of these retail and commercial tenants come 16 January are going to be back up to full rent, plus they're going to be paying accumulated deferred rents that have arisen from the previous 4 periods of rent relief. So I just think that both landlords and tenants are going to face potentially some real cash flow difficulties come the mid-January next year. And I guess what that's going to mean is, you know, the theory was that when tenants were able to recommence trading, everything would be fine. Their income would go back up to what it was, and they'd be able to start paying full rent and start repaying the accrued deferred rent from previously. I question how realistic that is. And I think for tenants, as from mid-January next year, they're going to have to obviously consider their financial situation and whether their business can sustain those rents. If they can't, then they're going to need to try and renegotiate with their landlords or potentially face the prospect of having their leases terminated. That's an unfortunate situation. And I think for landlords, from their point of view, they are going to have to consider what this is going to mean in terms of the rental income from those tenants. And it may be that landlords have to talk with their tenants and consider restructuring rentals, possibly even restructuring leases from January next year. Hopefully at that point we'll be past the worst of COVID and they'll be able to make more long-term and reliable plans. But really the point of my presentation just now is to highlight those looming potential cash flow crises for tenants, which inevitably will flow through and affect the owners of those buildings as well. Thank you. That's all for me.
Thanks, Steve, and all the presenters. We did promise that we'd answer some of your questions. So we've had questions flowing through both on the chat and also questions being put to us prior to the webinar. Some of the questions are quite specific to your business and industry, and some of them we may need to do a bit of research and come back to you directly. But some of the more general questions, they tend to be around the workplace relations issue. Not surprisingly, we're all grappling with that, with the vax rules, etc. So mainly for David. So David, firstly, there's a question from Susan about employers need to keep, then whether they need to keep records as to vaccination. So Susan asks, and she's in an accounting firm, are we required to keep a copy of the vax certificate of staff, or is it sufficient for us to just to cite and record it?
Yes, good question. Well, if the work you do is covered by a public health order, then yes, certainly in Victoria, it's mandated that you collect and use those records. But as I mentioned before, there was actually another question on this issue in relation to accountants as to whether they're covered by the directions. And my understanding is they're not, unless they're in the business of providing advice on financial services products. So it may depend on the nature of the business. But otherwise, if you are not covered by the directions, then there's not a legal requirement that you collect the information. You can just cite people's vaccination status. However, having said that, in order to fulfil your statutory health and safety obligations, it'll be easier to do that properly if you actually collect that information and use it. Because if you have an employee coming to your workplace or a contractor or anyone else who's unvaccinated, then you need to be taking some risk control measures as well, noting that that person's not vaccinated, to minimise the risk of them spreading COVID to someone else in your workplace.
Thanks, David, and stay with us, David. Some more questions for you. We had a question from one of the council officers about whether council staff can require their contractors to be vaccinated, those contractors performing work at council offices or on council sites, and ought this be incorporated into some form of contract?
Yes, good question. Well, certainly, if the contractor is involved in construction, then they're automatically covered by a public health order, and that is mandated anyway. And in order to comply with that, you can require the contractors to provide you with information. But otherwise, again, it comes back to council discharging its duty of care obligations in relation to health and safety, and it's perfectly reasonable if council makes a decision on that basis for you to require any contractor who is either entering council offices or will be coming into contact with council staff outside of council offices. It's relevant for council to say, yes, we require you to provide details of your vaccination status. It doesn't have to be formally added into a contract. You can just issue that requirement. You can potentially, if you want to, make it an addendum to your contract, a one-page addendum, which can be provided to the contractor, but that's not essential given we're talking about short-term issues here, but you can certainly put it into the paperwork if you want to.
And David, as our borders reopen, we've had a question from Julia about those international employees who are travelling back to Australia who may have been vaccinated overseas. You know, are we recognising the status of those international vaccines, and where should we be looking to find the answers to that?
Thanks, Sonia. So I looked at that question, and it suggested at the moment that some of the vaccinations are currently not recognised by our authorities. If that's the case, then I wouldn't have thought they would be able to get back into the country. So that is the brief answer. But if they are able to get back into the country, despite the fact that their vaccinations are still not currently recognised, then it becomes a matter of your own policy as to whether you're prepared to allow them into your workplace. But my advice would probably be in that situation, if the Australian government experts have decided in their wisdom to let them into the country, then it wouldn't be unreasonable for you to let them into your workplace.
Absolutely. Greg's asked a question in relation to the health and hospital sector, whether clients of an allied health provider who meet with the provider in a hospital need to show vaccination status?
Absolutely. Well, that's covered off certainly under the directions relating to healthcare in Victoria, and I think probably in most jurisdictions that allied health providers who are required to enter healthcare premises, be they public or private, are required to be vaccinated and required to provide evidence of that.
Good stuff. And someone's asked a question about what about first-time employees, new hires? If we start hiring employees for the first time, do we have to make them go and get the vaccine before they come and work for us? I guess that the same rules apply to those new employees as our ongoing employees, David.
Absolutely, Tony. In relation to, well, if your workplace is covered by a public health mandate for the vaccination, then absolutely any job applicant, you need to inform them that they are required to comply with the public health order, and that includes being fully vaxxed either by the relevant date in November or before they start if they're starting after that date. So yes, that's necessary. If there is no public health order that applies, then it's entirely dependent on what your own business policy is in relation to mandating vaccinations.
So, well, ladies and gentlemen, we've run over time a little somewhat. We hopefully we've given you some good direction today. There have been some other questions that have gone through. If there's more specific questions, if we can, you can sort of send them through to us directly, also on the email addresses on the screen there, and we will certainly endeavour to get back to you with our thoughts on those. Thank you today for bearing with us. And hopefully you got some good value out of this. And as I say, don't hesitate to contact us directly. We are, often in a position where we can assist you, with a simple matter, with a simple answer very quickly, and perhaps set you right and allow you to sort of have that resolved very quickly. Thanks a lot, and we'll hopefully you can join us at a future webinar.
Thank you.